Location, location, location. No, this is not the real estate portion of our program. We're here to talk about venue selection. Properly selected, the forum for complex business litigation trial can set the tone for the entire case. Even if a plaintiff initially appears to have the upper hand, a change of venue could even the playing field or give you an advantage. Here to discuss venue as a litigation tactic, please welcome Nicole Bearce.
Hi, good morning. So in the context of real estate, of course, I think all of us have heard the phrase how important location, location, location is. And in the context of complex business litigation, it's no less so. And in fact, it is one of the most significant issues that can impact a lawsuit. And what I'm talking about here is venue, which is the location where the case is ultimately tried. Now, venue is selected at the outset of the case, obviously by the plaintiff, since they are the one who initiates suit, but that does not mean that venue has to remain the same throughout the pendency of the action. Depending on where the case is venued, you can have different jury pools, different jury awards in terms of liability and or damages. You can have different judges. You can have different court management systems, and harking back to the initial program that was put on this morning by John, you can have different standards that are applicable to the admissibility of expert testimony, which can certainly impact how a jury trial might proceed. So it is something that you want to be cognizant of at the outset, but also throughout the pendency of the litigation, because as I'm going to go through, there are a couple of different instances where you may have an opportunity to shift venue even after the initial stages of the case. It will impact your litigation strategy as well as potential outcomes. Now, the plaintiff chooses where to file suit, and depending on what jurisdiction you are in, that selection is accorded certain deference in different circumstances. But that does not mean, as the defendant, that you don't have the opportunity to raise a challenge if you believe that there is another forum that is most appropriate for the case to be considered. And the way that the courts analyze this issue is under an analytical framework that's called the interests of justice, which includes two critical components. It includes both convenience, and that is convenience for the parties as well as the courts, and that includes fairness. And I'm going to go around full circle, I think, by the end of the presentation and point out some circumstances where there can be problems when the courts emphasize in a disproportionate way efficiency over fairness. So it is important to consider both critical components. Now, it's worth pausing for just a minute to harken back to our law school days, to the fundamentals that need to be considered when a lawsuit is filed. And I want to point out that the concept of venue is distinct from jurisdiction. Jurisdiction, of course, is required for a court to have the power or authority to decide a cause or controversy. But venue is the location where the case will ultimately be adjudicated. Now, the venue might already have been determined if there is a contracted issue and it includes a forum selection clause. Although forum selection clauses had historically not been favored, they are now pretty much granted deference by the courts. So I would say if you are in a circumstance where you've got a forum selection clause in play, you're most likely going to be stuck with that provision. So what I would emphasize is that if you are negotiating contracts that include these kinds of clauses, it's something that you want to be cognizant of the various factors that I outlined at the beginning, including different jury pools, different judges, different court management systems, because it's going to be much more difficult to get out of that situation. Depending on the causes of action that are asserted by a plaintiff, there may also be peculiar venue rules that apply to specific statutes. But what I want to focus on here are situations that are murkier. Situations where you don't have a clear forum selection clause, situations where you don't have a provision in a statute that tells you where you need to be, and situations where there are multiple places where the case could be considered. Now, of course, you always want to start with the rules because you always start with the fundamentals. And if you are in either state court or in the federal framework, there are criteria that lay out where venue could be laid. And in the state court systems, and these are pretty typical across the jurisdictions, of course you want to focus on the specific jurisdiction that you find yourself. It will include the county where the defendant lives or resides, the county in which the defendant has its principal place of business, in which the plaintiff's claim arose, the county where the defendant's actions gave rise to the cause of action, and if there's property involved, the county where that property is situated. Now, in federal court, whether you're dealing with diversity jurisdiction or subject matter jurisdiction, the criteria is essentially the same, worded slightly different, but essentially the same. And as recently as 2011, there was a new provision added to Title 28, which clarified what venue meant, and that was because the comments indicated that the courts were spending so much time wrangling with the parties over jurisdiction and venue that it was deemed to be necessary to clarify when you're talking about venue, it's not the power or authority of the court to hear the case, it's the appropriate location. So, the fight over where to fight. When you are served with a complaint, the first thing that you are going to be dealing with is how to respond to that complaint. When you file your first pleading in response to the complaint, you do want to be sure to preserve your ability to object to venue. So just as a fundamental, initial step, you want to preserve that, so you want to include that in your first pleading. That being said, there are other stages along the way where potential motions to change venue can arise, and I'm going to highlight them here. You can move to change venue under either Section 1404 or 1406 to Title 28 if you are in federal court. You can move to change venue under the common law doctrine of forum nonconvenience, which would typically be in a state court that doesn't have a similar framework to the federal statutes. You can deal with consolidation efforts under the Multi-District Litigation Act or state multi-county litigation programs, and of course there is removal. We could probably do a whole presentation just on removal, so I'm not going to focus on that here today. I will just say that my rule of thumb is if you can change the forum by removing a case from state court to a federal forum, it is pretty much always my advice to do so. You obviously want to be attentive to the specific circumstances in the case that you are presented with, but with that rule of thumb, let's focus on the other three that I've outlined here. Starting with motions to change venue under either Section 1404 or 1406. Under 1404, it provides that for the convenience of the parties and witnesses in the interests of justice, a district court may transfer any civil action to any other district where it might have been brought. Now let's contrast this to 1406, which provides that if you move to change venue under 1406, you're actually seeking a dismissal of the claim from the initial district and asking that it be refiled in a different district because the initial district was inappropriate in the first instance. The difference between the two is that under 1404, it's not that you are claiming that the initial forum was wrong, but what you are asserting is that there is another forum that is more appropriate. When defendants are in a position of seeking to change venue, sometimes as a default position, they will assert both 1404 and 1406 as the basis for their application. And I want to just put out a word of caution when doing so, because under 1404, if a case is transferred to a different district, the choice of law principles that applied in the original court travel with that case. And that is because the basis for a 1404 transfer is not that the initial district was wrong, but that there is a more appropriate forum elsewhere. Under 1406, if you have the initial case dismissed and transferred to a different district, it is the choice of law principles of the new transferee court that applies. And so if you are dealing with a situation where you are looking to move a case, if the choice of law principles in one district are more favorable to you than another, you don't want to, out of a default position, assert both grounds, because you may end up being in a position where you were trying to avoid the application of the choice of law in the original district, but you cited 1404, and now you're stuck with it. So it's something that you want to think through. It might be appropriate in certain circumstances where there isn't a difference from your standpoint with regard to the application of those choice of law principles, but think it through and be cognizant of it when you're asserting a basis to move a case from one district to another. Now, the factors that the courts consider under a 1404 or 1406 application are similar to what is articulated under the common law doctrine of forum nonconvenience. And that is because forum nonconvenience is the ancestor to that federal framework. So I'm going to outline here what courts consider under both rubrics, but understand that the origination is really from the forum nonconvenience common law doctrine, which is now also included under the statutory framework. So in a forum nonconvenience application, which would be in a state that didn't have a comparable framework to the federal statutes, the party is asserting to the court that although there is the proper exercise of jurisdiction in two different fora, there is one that is more appropriate. And the court engages in a balancing test to determine whether or not the case should be moved. And there are both private interest and public interest factors that the courts will take into account. Private interest factors look to the specific litigants that are involved in that specific case. So they will look to things like relative ease of access to proofs. They will look to see where are the business records located, where are medical records located if there are personal injury claims, where are the witnesses located, where are the witnesses subject to compulsory process if you've got witnesses who are not going to be cooperative. It will also look to where a piece of property, or if there is a facility that is at issue, or a particular manufacturing plant, they will look to see where is that facility located. Those are the private interest factors that the courts will consider. On the other hand, the court will also consider public interest factors. Now, public interest factors looks at the dispute and considers from more of a policy, broader societal context, where should that case be decided. This looks at factors such as judicial economy. It looks at things such as relative congestion of the case management dockets in the different jurisdictions. It will also look to see if there is a particular localized interest in having a dispute decided in a specific locale. And one of the factors that it will take into account in that regard is the imposition of jury duty. Where is it appropriate to impanel a jury when you've got a dispute that is being decided? Is it something where it arose within the borders of a specific forum, and so the jury should be impaneled from that forum? Or is it something where it doesn't have a substantial nexus to that forum, and then it's something that would not weigh in favor of transferring the case? In addition to a 1404 or 1406 transfer motion, or a forum nonconvenience application, you may also be facing consolidation efforts under the Multi-District Litigation Act, or some states have multi-county litigation programs that are comparable to this. The underlying principles for the MDL and for multi-county litigation programs focus on the judicial economy that is achieved when multiple actions that exist in either different districts or different counties are centralized for management purposes. I wanted to point out that in the MDL Act, as well as in a number of state multi-county litigation programs, it's important to keep in mind that the cases are aggregated for case management purposes, but they are not consolidated in the way that a class action would be. The individual cases maintain their unique identity as component cases. And so even if the cases as a collection are managed throughout the pretrial and discovery process, when you get to the point where it's time to try the case, it is important to look to that individual case that is actually going to be heard by the jury and weigh whether or not it makes sense to make an application to remove that case and have it tried in a different location. The MDL Act provides, and I have the language bolded at the end of this slide, that a panel may separate any claim, cross-claim, counterclaim, or third-party claim and remand those claims before the remainder of the action is completed. And again, it's done on an individual basis. And similarly, there are state multi-county litigation systems, and New Jersey is one of them, that also provides discretion in the multi-county litigation judge to sever and remand individual cases if it appears that it should be tried in a different location. So I'll give you an example. We represent a large pharmaceutical company that has a facility in a particular county in New Jersey. It's been in that county for more than a century. It's a rather large mass tort action. All of the plaintiffs are located in and around that county. All of the operative facts underlying the claims arose in that county. The facility is located in that county. But for administrative purposes, under the multi-county litigation system in the state, the Supreme Court designated it to be handled by a judge in a faraway county. Now, I don't know how many people in the room are from New Jersey, but there is actually a difference between North Jersey and South Jersey. Sometimes it's more pronounced in certain circumstances than others, but it's more than 100 miles away, although it's within the same borders of the state. We are now at the point where we've been going through pretrial discovery, but a bellwether pool has been selected. A trial is scheduled to take place in February of next year, and we just recently made an application before the MCL judge to try and sever and remand that bellwether trial back to the home county where the cases had originally been filed, based on all of the factors that I just outlined for you, that the locus of operative facts was in that county. There is no connection to the county where it's sitting right now. The only reason it is there is because it was deemed to make sense to have that judge oversee the case, which was decided over 5 years ago. Now, the judge was clearly uncertain as to whether or not she should remand that individual case back to the home county, and indicated that she wasn't aware of that ever having been done before. And it's not that there isn't authority in the program itself to make the application, but there doesn't seem to be a precedent for it having been done. And so it frankly sparked my interest in speaking on the topic, because I do think that when you're dealing with these complex cases, it may become more of a default that there's an assumption that the case should just stay where it's been worked up for pretrial. And so, unfortunately, the judge denied our application, but we're in the process of putting together an interlocutory appeal for the very reasons that I already outlined. And so it's something that you want to be cognizant of and you want to think about, because on appeal, while certainly the court is exercising discretion and there is a deferential standard to the exercise of that discretion, if the standards employed are incorrect, then that is subject to plenary review. And so we will be teeing that up. So why do we even care about this? We care about it for the various reasons that I outlined at the beginning, and what I wanted to circle back to is when you're thinking about different jury pools, different jury awards, there is a fundamental fairness that is part of the interest of justice calculus that you can position in a particular way in your application to try and best present a convincing argument to the court to allow you to move the case to the most appropriate venue. Real jurors bring experiences and values that are based on their particular experiences living in a certain location at a certain time, and based on their experience as a person of a particular race, gender, and economic class. If we recognize this, it is not to impugn the impartiality of juries in different locations, but rather it is to recognize the role of jurors as representatives of the particular community in which they live. And when you have a lawsuit that has the locus of operative facts in a particular location, then it makes sense both in terms of weighing the private interest factors and the public interest factors for the case to be heard before a jury impaneled in that location. So whether you are moving under 1404, 1406, forum nonconvenience, or under the MDL Act, these are the various factors that you want to be sure to keep in mind, and I thank you for your time this morning.